Mic test. Going.
Oh yay, all rise. The Supreme Court of the United States is now in session.
Please be seated. We are here today to hear argument, case number 23-286, Michael Nelson versus Mega Shop Incorporated. May I have announcements by the parties, please?
For the petitioner, Aaron Holmes, and my co-counsel, Aaron Kelly, Your Honor, we are team 13.
Okay. Can you please spell your?
Yes, AARONHOLMES.
ERINKELLY.
And team 13? Responded?
1310. My name is Erica Kuntz, ERICA, Kuntz, KUNTZ.
And I'm Giancarlo Quinto. That is GIANCARLOYAQUINTO.
Thank you very much. And it's my understanding that you've already given your times to the bailiff.
Yes, Your Honor.
Wonderful. Please proceed at your convenience.
Thank you.
Madam Chief Justice, Associate Justices, and may it please the court, my name is Aaron Holmes, and today, together with my co-counsel, Ms. Erin Kelly, we will be representing the petitioner in this matter, Mr. Michael Nelson. If it please the court, we would like to reserve 4 minutes for rebuttal. Thank you, Your Honor. This is a case that raises two important issues that threaten to erode the rights of disabled individuals across the United States. Because Mr. Nelson was a disabled employee requesting reasonable accommodation, his request should have preempted the application and hiring process. And because his employment was denied on the grounds of discriminating against his disability and the medication prescribed to treat his disability, without consideration of illegality, except for a post hoc rationalization, the decision of the District Court and the 15th Circuit Court of Appeals should be reversed in this matter. Now, Your Honors, to date, the 10th Circuit Court of Appeals, the 7th, the DC Circuit Courts, and the Equal Employment Opportunity Commission have all held the same, that reassignment, like other forms of reasonable accommodation, should entail more than mere equal treatment to ensure that equal opportunity is achieved. What we're discussing is a fine line between passive, non-discriminatory behavior and active accommodation when requested. Taking positive steps, making adjustments, providing things that are not typically provided to non-disabled employees may appear as preference, but in fact, it is inherent to the concept of reasonable accommodation. Because to put it plainly, the goal is not equality of treatment. The goal is parity of opportunity. And to achieve that, sometimes reasonable accommodations are not only needed, but demanded by the Americans with Disabilities Act. The EEOC has issued very clear guidance on the issue of reassignment as it is required in 12-111-9B of the Americans with Disabilities Act.
But counsel, in this particular case, your client was not as qualified as the individual that eventually received the position that he would have been reassigned to. Is that correct?
That is correct, Your Honor. We have stipulated it so.
So at what point would a qualification be too much? I mean, should he be assigned to any parity job that gives him the same benefits and pay, even if he is not qualified for it, for instance?
Your Honor, that's a very good question, and it straddles a line between two sides of this issue. The first side being that in the current case, Mr. Nelson is an employee first. And before we even get to the issue of whether or not a best qualified applicant policy works in the context of new hires, it needs to be addressed that as an employee, he was not afforded a reasonable accommodation for his disability by reassignment, when no other reasonable accommodations would have worked to keep him in his current position. And so, as required by the ADA, to either accommodate reasonable accommodations or to show evidence that it will be undue hardship on the company, that process never occurred, Your Honors.
Are there any facts in the record showing the Mega Shop did not suffer undue hardship under the circumstances?
There are no facts on record to suggest what kind of hardship, undue hardship, that Mega Shop would have suffered, if any. And in fact, it is the obligation of the employer, once a reasonable accommodation has been made, it is the obligation of the employer not only to present undue hardship evidence, but to present it with particularity. 29 CFR section 1630.2P specifies that undue hardship must be presented in concrete terms by analyzing certain factors. How much financially will it cost the company? How much financial resources does the company have? What are the geographic considerations? How many people does the company employ? All of these things, and in fact, Your Honor, it goes beyond that. 1630.2P suggests that an employer must consider all sources of funding when making considerations for undue hardship, including state rehabilitation agencies, tax credits, deductions, even to the point of asking the individual if they are willing to take the cut to make up the difference. None of this occurred with Mega Shop in this particular case. In this particular case, the fact is that no reasonable accommodation was offered.
Counsel, isn't there a policy with the Mega Shop itself that they would hire the best fit candidate for a job?
There is, Your Honor.
So if that's the case, then why is there an issue in them following their own policy? Do you have an issue specifically with all companies having a policy like that?
Absolutely not, Your Honor. And in a circumstance where a disabled person not already employed by the company applied for a job, the blanket non-discriminatory policy that always applies would apply in that circumstance. They should expect no accommodations, specifically for the reason that they are not already an employee of the company. Therefore, the company is not obligated to provide them with an employee's accommodations. If accommodations had been made to keep Mr. Nelson in his current position, and he had decided unilaterally that he would prefer a change to a reassignment to another job, even in those cases, accommodations would have been provided, and they would be free to employ their best qualified policy. In fact, they are still able to employ this policy to their benefit. The position that is being vacated by Mr. Nelson needs to be filled ostensibly, and they are free to fill it by seeking out the best qualified candidate.
And so again, the company should accept a lesser qualified candidate in a particular position because of the ADA requirements of providing a reasonable accommodation. Is that essentially your argument?
Accept is perhaps not the word I would use, Your Honor, but in a nutshell, you are absolutely correct. The ADA is fairly clear. Now, they do make allowances, and the EEOC clarifies that in the vast majority of cases, reassignment is what's known as an accommodation of last resort. Once all other options for accommodation have been taken off the table, then reasonable accommodation of reassignment is an option and is expressly stated as such in 12.112A of the Americans with Disabilities Act as a reasonable accommodation. So if they have not accommodated their employee in any way, and this is the last one on the table, then yes, in that circumstance, Your Honor, they've painted themselves into a corner, and that is what the law requires.
Counsel, the act itself says that reasonable accommodations may include, and there's a list. At the end of that list, it says, and other similar accommodations for individuals with disabilities. What would be an example of another similar accommodation for this individual with disabilities under the circumstances?
I am happy to answer, Your Honor. I did see the 1-minute warning before you started speaking. If you'll allow me some extra time, I'll answer your question quickly.
Please.
An example of another accommodation that would work would be if the company were able to provide some specialized lifting equipment or something that would allow Mr. Nelson to continue potentially in the same job that he is in. If the company had another vacant position that they felt he would be better suited for, and that was roughly equivalent to these 2 or 3 positions, that would also be an option, Your Honor. There are a wide range of possible accommodations that could have fit the bill and simply were not taken or were not available. Thank you, Your Honor.
May it please the court. Your honors, today we are focusing on 2 issues within the second question presented. The first issue discusses the ambiguity of the ADA's language, with the second issue discussing the ambiguity of the law. Your honors, this case is fundamental to ensuring the rights of disabled persons to receive employment accommodations, even in cases where conflicting federal and state laws make the legality of the prescribed treatment ambiguous. Under Title I of the ADA, Mr. Nelson qualifies as a member of a protected class. Therefore, Megashop's refusal to accommodate his disability by reassigning his job position violates 42 U.S. Code Section 12.112A, which mandates no entity shall discriminate against a qualified individual on the basis of disability. Megashop not only discriminated against a person with a disability, they more egregiously used his medical treatment, which is prescribed and supervised by a board-certified physician as the basis of their discrimination. The manager of Mega Shop, as stipulated on the record, pages 5 and 9, was opposed to drug use of any kind for any reason. Mega Shop acted on the basis of this manager's bias in the absence of any official policy on the matter. Because of this,
But counsel, you would agree that by not providing your client with the position, they ratified that decision by the manager. So it did become a policy.
Your Honor, if you allow me to finish the point, I think I will answer your question. Mega Shop's decision to act on the basis of Mr. Nelson's prescriptive use occurred before any consideration of illegality. Mega Shop therefore discriminated against a disabled person on the basis of disability, meaning that should my client have been prescribed Oxycontin, specifically legal prescription narcotic, the result would have been the same. They did not discriminate on drug use of the illegality of marijuana. The manager said they do not take any drug use of any kind.
That's not my understanding.
Nowhere in the facts, Your Honor, does it state the illegality. The manager said no drug use of any kind. Your Honor, may I continue?
Please.
Mr. Nelson's compliance with the state law to utilize a doctor-prescribed medical treatment is under attack due to the ambiguous language offered by the ADA's exceptions in 42 U.S. Code, Section 12.1.11.6. This section explicitly states that the term illegal drug use does not include use of a drug taken under supervision by a licensed healthcare professional. A drug that is taken under the supervision of a licensed healthcare professional is not included in the ADA's definition of illegal use of a drug. In fact, the ADA lists 3 specific exceptions. A drug taken under supervision by a licensed healthcare professional means not an illegal use of drugs. Use is authorized by the Controlled Substance Act means not an illegal use of drugs. Provisions of federal law means not an illegal use of drugs.
So if the prescriber had prescribed him instead of marijuana, cocaine, that still would have been acceptable because it had been prescribed by his.
If it was legal in the state to prescribe cocaine, yes.
So if it wasn't legal in the state, then it wouldn't have been okay, but because the marijuana law in.
Yes, if we had had a cocaine law in place, I mean, there's no debate. Marijuana is a Schedule I legal narcotic like heroin or cocaine. So should it be allowed in the state? It would be allowed. The ADA's ambiguous terminology requires my client, Mr. Nelson, to interpret and exceed the scope of the general rule of law according to the expressed exceptions to follow the medical advice of a board-certified physician overseeing his care. To date, this debate has not been solved by the brightest legal minds in our profession, and yet we are asking a layperson to interpret, understand, and execute the legal possibilities and ramifications of simply taking a medication prescribed by their board-certified physician. How is this a representation of justice?
Counsel, if we were to adopt the Ninth Circuit's interpretation under Costa Mesa, then what happens with your client?
So in Costa Mesa, the facts of that case were, although not most, analogous to ours, the holding was in the sense that they extended quite the sympathetic nod to the state and acknowledging this is a very difficult decision and maybe we should be looking at this differently. They ultimately did go and and decide to go with the ADA, which then looked at the CSA, which is not in our favor. And that is why we're here today to ask you to change that and to take the lessons that were learned in the Ninth Circuit that perhaps we should be looking to the state. And I'd like to, at that kind of leads me to the Constitution, which has offered no distinctive ban on the use of marijuana as a medical treatment, and therefore the federal government is overreaching by not upholding the state law. Not allowing the states to supersede the law is not evident in the Constitution. It's a direct violation of the 10th Amendment. State officials are elected by their constituents to implement laws that best suit the needs of their people. And if the federal government just invokes the necessary and proper clause each time it doesn't agree with the state's decision, the will of the people is not met, and the efficacy of state-level elected officials is officially rendered useless.
Was the 10th Amendment argument brought up in the courts below?
Your Honor, I don't have that information in front of me.
So you would agree that if this is the first time we're hearing it, we probably can't consider it?
I believe you can, if my recollection is correct, it is mentioned and you can consider it. I just don't have that exactly in front of me, and I don't want to speak on something I don't have directly in front of me. Thank you. Going back to your Ninth Circuit question, I wanted to read directly from that holding where it says, decided by the majority, the language written by the ADA could reasonably be interpreted to create two or more exceptions, and the majority explained the language lacks plain meaning and its legislative history is not conclusive. Your Honors, I would really like to focus that we have the wrong person on trial. Is it not the doctor who should be held accountable for interpreting and following the law regarding what and how he can prescribe and treat? Physicians are regulated by our federal government and risk losing their licensure and DEA number, which authorizes a physician to prescribe any drug deemed appropriate for medical treatment. It is the physician that is not upholding the law. My client is an innocent bystander and the obstacle preemption imposed by the ambiguity of this law. By following the orders.
If you think that the physician is not following the law, then doesn't that render your argument moot?
If Congress did not want that exception, excuse me, let me rephrase. When we look at the three exceptions under the ADA, there is the exception of taken under the supervision of a healthcare provider. That's explicitly in there, and it's to be interpreted that any drug taken under the supervision of a provider holds the same amount of weight as every other exception. If it didn't mean that, Congress would have simply removed it. What is concerning is placing blame on patients who are following state law that conflicts with federal law. And we have to look to where federal law is overriding a state's ability to choose what's best for its people. And why do we even have state law if the federal law can just keep overriding it? My concern is that this court would then be solidifying for this state and the many other states who have already done this, that you can choose the best course of action and not harm patients. The physician is most likely to know the law, understand the law, and know what is at risk should they prescribe an illegal narcotic.
Are you suggesting that people are not responsible for knowing the law, despite well-established maxims of the contrary?
Ignorance of the law is no defense, Your Honor. However, when we do go, Your Honor, I am at time, I'm happy to finish.
Please continue.
Much like when a client comes to us, they come to us with the expectation we know how to best serve them through the eyes of the law and not commit malpractice. When a patient then also goes to a doctor, there's the assumption that this person knows more than them and is thus prescribing them what they can take that will not harm them physically, also not harm them legally. And further, for this specific case, not be used against them with their disability. Thank you, Your Honors.
May it please the court. My name is Erica Kuntz, and alongside my esteemed co-counsel, Giancarlo Quinto, we stand resolute today in our representation of Megashop, a business that prides itself on upholding both legal standards and fair employment practices. Today, I'm going to first unpack the first issue regarding the ADA's provision concerning reasonable accommodation, offering clarity, and dispelling prevalent misconceptions. Following, my co-counsel will then delve into the complexities of the Texoma Medical Marijuana Act, underscoring its equally crucial importance to this case. The district court, in its wisdom, granted Megashop's motion for summary judgment, recognizing that the ADA is not designed as an affirmative action statute. This is on page 7 of the record. This means that while the ADA promotes inclusivity and fair treatment, it does not necessitate an employer to bypass the most qualified candidate in favor of another based solely on disability status. This interpretation, we argue, upholds the essence of merit in the workplace. Further, the appellate court rightly affirmed this decision, reinforcing the principle that every individual, regardless of their personal circumstances, is assessed based on their qualifications and the value that they bring to the role. So this isn't a matter of sidelining individuals with disabilities, but rather this is a matter of ensuring that all candidates are given equal footing and consideration on the merits. So for this reason, we ask the court today to affirm the lower court's decision. So at the core of this deliberation today lies not just the letter of the law, but also the spirit with which businesses and individuals like Megashop, Mr. Nelson, we navigate these complex issues of intersection of rights, responsibilities, and business realities.
So, counsel, what's your response to Mr. Nelson's argument that you don't owe that responsibility to an applicant, but you do to an employee?
In regards to not owing the responsibility to the
applicant of fairness and equity and those kinds of that reasonableness that you're just talking about.
Right, and most certainly, I think, and businesses should give employees and applicants alike equal opportunity and a chance, consideration, and we can look to the statute. And it's this is on page 7 of the record, and it reads that the act in the term reasonable accommodation may include job restructuring, part-time or modified work schedules, reassignment to a vacant position, acquisition or modification of equipment or devices, etc. And so the question is reassignment to a vacant position. Mr. Nelson was given the opportunity. However, there were other candidates that were more qualified, and this is a policy that we followed, an internal policy. And this has been, there is authority for this in the lower court's decision in Huber v. Walmart on page 7 of the record. And in fact, when the petitioner pointed out that this case held that it should reassign, that's not entirely true here. Well, really what the court said was that this was just not the ADA is not an affirmative action statute. And so at that point, the judgment affirmed that the ADA does not insist on preferential treatment, but in fact, it really, at its core, emphasized that there is a harmonious workplace balance that can be achieved without compromising. So both can be honored, and that is on page 7 in the Huber case as well.
What is your response to Mr. Nelson's argument that there are other reasonable accommodations that could have been offered under the statute, other than job reassignment?
Yes, Your Honor. In the statute, there lists plenty of
Note of the statute.
accommodations. And so in this case, we were kind of pigeonholed. There was really not much else we could do, given that he just simply was not the most qualified candidate. However, I'd really like to point out that Mr. Nelson was given an opportunity which he was qualified for the inventory packer position. And he voluntarily disclosed his illegal use of medical marijuana. And so he was perfect. We gave him that opportunity. He's
Not to interrupt you, but I know we're working on limited time. So what about accommodations for the original position that he originally had at your company? Were there any accommodations that were offered to him to keep that original position?
Your Honor, we don't have any facts on that at this moment, so I can't necessarily.
Would that have been, are there any facts in the record that indicate that would have also been your company's position, that they would have tried to make reasonable accommodations to keep him in that position? Or was reassignment to a vacant position the norm?
Mega Shop first follows the ADA. They're following federal law. Mega Shop is not here to claim that their internal company policies should trump federal law of the ADA. And so with that being said, the reasonable accommodation just simply wasn't available, and given the facts here today. And there was another opportunity. So there was ample opportunity. However, with the voluntary disclosure, it was just simply not possible. And at that point, Mega Shop's hands were tied. And really, we can look, I think the most important thing, and this court has done in Barnett, we can look to Barnett, that this very court decided that, and the apex judgment there enunciates that the principle of ADA, it's a vision of integration, not disruption. So it affirmed that we can respect established systems while also honoring business policies, balancing those with disabilities and their interests.
Counsel, if it's left up to the qualifications though, then wouldn't it be problematic where an employer were to just decide that being a lack of qualification or someone was better suited because they don't have a disability? Doesn't there need to be some sort of line drawn to prevent that type of issue?
I think there could be a line that needs to be drawn. However, in this case, if we compare it against a broader landscape and we're looking at it against a backdrop, we need to consider these broader, the broader economic fabric here, and also small businesses. Mega Shop, we have less than 100 people. However, there are plenty of other businesses with more or less. They're not represented here today, and so we're here to represent businesses, small and large, and fortunately, there are other statutes, there are other government programs that protect those with disabilities. However, looking at the business side, there's not the protection afforded there.
I mean, the ADA is the thing that protects the businesses. I mean, the ADA is the thing that protects the employees of the business of your size. Wouldn't you agree?
Yes, Your Honor.
So that is what we're talking about right now. We're not talking about other governmental programs. We're talking about the accommodations that you did or did not provide under the ADA.
Correct.
And so we need to focus on those accommodations and why, like my colleague just asked, why, what is your responsibility to show that you did or did not do to make reasonable accommodations for Mr. Nelson?
Our responsibility in this case, a responsibility that we fulfilled, was providing a choice, a very valid choice, and he was, and both sides agree here, both parties agree here today that Mr. Nelson was qualified for both positions under the statute specifically, that he could perform the essential functions. So with that being considered, we did our due diligence by offering him another position, which he simply could not take because he didn't follow the federal law, which my co-counsel will get into in the second issue. However, I think it's important to step back and look at a broader consequence of this, and the side of the statute that specifically says, that speaks to undue hardship here. We can look at a couple of different factors. We can look at financial burdens, I think, is one. We can ask ourselves, is it prohibitive relative to the size and nature of the operation of the business.
Mr. Nelson's counsel suggested that there were no facts in the record showing that there was an undue hardship. Do you concede that fact?
Yes, Your Honor, we can see that fact. However, it presents itself that we can postulate that there are several undue hardships, like as mentioned, the financial burden, operational difficulty. This can be restructuring jobs, and
This is
so.
just speculation. There's nothing in the record that indicates this.
No, Your Honor, but these are, I think, real-life implications that follow.
On what grounds would you ask us to speculate about facts that are not in the record?
On no ground, Your Honor. Further, when talking about going back to the operational difficulty and having to restructure jobs and create new positions, that's most definitely undue hardship. And it would seem, given that Mr. Nelson did have an option to be an inventory packer, would then we have to create a new position, and then this would kind of be a little bit of a slippery slope, given if all businesses had to follow this. So I see my time is almost up, so I would ask your honors today that we appreciate this nuanced balance between individual rights, collective good, between operational imperatives, and inclusive ideals. We reiterate our unwavering commitment to the principles of the ADA, even as we emphasize our responsibility to maintain our standards, serve our customers, and support our workforce. And this is why today, Your Honor, we ask that you affirm the decision of the 15th Circuit.
Thank you.
Your Honor, may it please the court. My name is John Carlo Quinto, and I'm here to discuss the second issue that is pending today about whether or not Mr. Nelson's protections under the ADA extend to his use of an illegal drug. Marijuana, under federal law, is illegal. However, the issue here is whether or not the state laws supersede in this instance. I'd like to begin with the fact that Mr. Nelson has been arguing that he still receives protection under the ADA, even though he is currently using a drug that is classified by the federal government as an illegal use of drug or an illegal drug. It is considered a Schedule I, which means that it has no palliative care and offers no benefit whatsoever, at least according to the federal government at this time. Secondly, I would like to go and return us to Section 12.114 of the ADA, specifically A. It's on the record, in the record on page 9. The petitioner's counsel only read the second half. I'd like to read the first half. The term illegal use of drugs means the use of drugs which is unlawful under the Controlled Substances Act. Specifically, this includes marijuana in all forms by the federal government. As you know, the CSA was created in 1970, and yes, the ADA was not enacted until 1990. However, if Congress had any interest in allowing the use of an illegal drug under the supervision of a physician, they had the opportunity in 1990 to make that exception.
Is there evidence in the record that it's your company's policy that marijuana use is not allowed by your employees?
The record does not reflect that marijuana use by employees of Mega Shop is considered a fireable offense. However, marijuana and all other drugs that alter any mental state offer a liability to all employers at any time whatsoever.
Is that whether they're using the drugs on or off site or on while employed or not, or while on the job site or not?
Yes, sir. I believe that all drugs that affect your mental state do not end with the use. They continue until you've reached a sobering point. And who is to say when the employee has stopped using said drug?
Is that a fact in the record?
No, sir, it is not.
Does that also then, because I imagine this is not also in the record, would that also go to drugs that are legal under the federal system that are also mind-altering drugs like opiates, any other kind of pain medications that are in fact legal? Do you believe that Megacorp would have the same opinion about this? Megashop. sorry.
Megashop, my client Megashop, would believe that any employee that is in a dangerous position that is taking a mind-altering substance creates a liability,
At any time?
unless 100% sober. To return to the issue here, this is not an issue of discrimination. This is an issue of whether or not Mr. Nelson is protected by the ADA. The ADA makes it very clear that the use of illegal drugs means that the protection is no longer offered. Marijuana, according to the federal government, is an illegal drug. Until the law has changed, this is a very simple matter of statutory interpretation. The judges in James v. City of Costa Mesa were extremely thorough in their statutory interpretation.
If it were a simple matter, we would not be here because there wouldn't be a circuit split below. And so reasonable judges have come to different conclusions about this. Isn't that correct?
Your Honor, Judge Berzone's dissent offers coulds and mights, not shoulds or wills. Judge Berzone is very cautious in her dissent and offers very little other than possibility. While Judge Fisher offers concrete use of statutory interpretations and the canons themselves. Specifically, whenever you're reading 12-111-6A, beginning with such term does not include the use of a drug taken under supervision by a licensed healthcare professional, comma, or other uses authorized by controlled substances or other provisions of federal law. Originally, Judge Berzone argues that the other, in this instance, would imply that there is a separate interpretation that creates two exceptions. One, for any drug that is used under the supervision of a healthcare physician, or any drug that is allowed under the Controlled Substances Act. Judge Fisher, however, believes that the other would create, if you allow the interpretation of Judge Berzone, the other creates a surplusage, which would lead to semantic dissonance, creating further ambiguity within the statute and not offering any other clarity. Secondly, in footnote 7 of the James v. City of Costa Mesa case, there is Judge Fisher, in their thoroughness, went so far as to consider the rule of the last antecedent. In this instance, the rule of last antecedent would appear to help Judge Berzone's interpretation. However, because it is not absolute, and because the rule of the last antecedent must yield to the plain language and the legislative history of the statute itself, in this instance, all of what Judge Berzone offers is unfortunately a reading that is more wishful than supported.
Counsel, I think I just heard you cite to legislative history. I thought there was something in the opinion saying that there was no relevant legislative history that was helpful on this statute. Am I correct in that summary?
Your Honor, I disagree wholeheartedly. In fact, in City of Costa Mesa, specifically on page 400 of that opinion, you can find that the House version of the illegal drug exclusion was chosen over the Senate version. We are not persuaded, however, that this history compels the plaintiff's interpretation of 12-111 6A as it is now currently considered. It is very clear in James v. City of Costa Mesa that there is in fact legislative history that does support their interpretation and the interpretation that we're asking you to agree with, that the 15th Circuit has also agreed with. Further, also published in terms of the House Committee report includes a brief passage that could be considered to support this this secondary interpretation, but unfortunately, it rests on an unstated assumption that while plausible, is not actually in the record itself of the congressional history. And so for this instance, while the record of Mr. Nelson v. Megacorp does not include any legislative history, the case James v. City of Costa Mesa offers plenty of legislative history about the ADA and the specific statutes that we are looking to interpret at this time. Again, I want to reiterate that marijuana is a Schedule I drug. The federal government recognizes no palliative benefit whatsoever from it at this time. We're not here to make new law. We are here to interpret the current law as it stands. And while there is ambiguity, and that is why we are here, Judge Fisher in James v. City of Costa Mesa is thorough in explaining which canons work and why they work, and specifically stating that the interpretation that Judge Rosone offers in their dissent, while persuasive with pathos, is unfortunately falls short, because
Counsel, isn't it too far of a stretch to say that we're unable to know whether or not this is beneficial in any way if the state itself has allowed it for medicinal usage? Clearly, there are physicians within the state who are using it for a purpose of aiding a patient in some way medically. So doesn't that go too far against medical purpose?
Your Honor, I don't disagree. However, I would argue that at this time, the government of the United States does not view any benefit whatsoever. And as such, even though the states themselves may believe that there is a palliative benefit from the use of marijuana, unfortunately, because the court is restricted by the legislation and the legislative body and the statutes that we currently have, the Controlled Substances Act lists it as a Schedule I drug, which is explicit in stating that there is no palliative care of any of the drugs that are on there.
Counsel, is it your position then that we should turn a blind eye to the 10th Amendment?
Your Honor, I believe you asked petitioners if that was anywhere in the record.
I did, and they said it was not. My question to you is, should we turn a blind eye to it?
When you say a blind eye, Your Honor, I am failing to see the argument of the 10th Amendment that would that we would be turning a blind eye to.
Fair enough.
Thank you, Your Honors.
May it please the court. Although there are many issues to address regarding opposing counsel's arguments, first and foremost among them must be that opposing counsel has conceded that there was no undue hardship excusing them to turn down a reasonable accommodation. When asked pointedly, and on more than one occasion by this court, that point was conceded. And when asked if the court was free to speculate about the facts and under what conditions they were free to do so, opposing counsel asserted that this court is not free to do so. Under that fact alone, Your Honors, without undue hardship demonstrated, then once a reasonable accommodation has been suggested, then the ADA requires that it is complied with. That apparently seems to be what has occurred here in this case. Setting that aside for the moment, opposing counsel suggested that that the ADA was not intended to be an affirmative action statute. In saying this, she was citing Huber versus Walmart out of the Eighth Circuit. And we wholeheartedly agree. We do not think the ADA is an affirmative action statute, Your Honors. We do not believe that it requires preferential treatment over and beyond what a reasonable accommodation would ordinarily require and what passive non-discrimination would ordinarily require. We further don't believe that it purports to impose some kind of quota on a hiring process. Opposing counsel has suggested that employers and applicants should be treated the same. The Americans with Disabilities Act contradicts this reading that current employees are owed some special obligation beyond those that do not currently work for the employer. Opposing counsel has suggested.
Wouldn't that contradiction then be affirmative?
I'm sorry?
Wouldn't that contradiction that you stated then be affirmative?
In what way, Your Honor?
You're saying that it has, like nothing to do with whether it's an employee or an applicant. You're gonna decide differently for these people. And that's taking an action to
No, Your Honor.
I'm sorry. Earlier in your argument, you stated that we should look to the current employees differently from the applicants, right? In a case like this?
That is not exactly what I said, Your Honor. What I said is that current employees are owed, according to the Americans with Disabilities Act, certain accommodations required under the letter of the statute that are not required to those who are not current employees. An employer may be required to change the lighting in an area to accommodate one of its employees. It is, however, not required to go and change that lighting for an applicant until that applicant has become an employee and then requires that accommodation to do their job. So I'm not suggesting that they are treated in any way differently during the hiring process, simply that once they become an employee, the reasonable accommodations laid out in the ADA are required for employees and not for mere applicants. Thank you, Your Honor.
Thank you. Case is submitted. We're adjourned. Do you want us to listen?